Good morning, everyone. I see people joining. We'll get started in one minute. There's more people joining. All right, good morning, everyone. My name is Enrique Zuniga, and it's my pleasure to welcome you to this virtual public hearing. This hearing is being conducted jointly by the Massachusetts Peace Officer Standards and Training Commission, which is commonly referred to as the POST Commission, and the Municipal Police Training Committee, which is often referred to as the MPTC. As I mentioned earlier, my name is Enrique Zuniga, and I am the Executive Director of the POST Commission. Today's hearing concerns proposed amendments to the regulations governing the use of force by law enforcement officers, which regulations have been promulgated by the two agencies. This hearing is being recorded, and we ask that you mute your audio when it is not your time to speak. Joining us remotely on behalf of the POST Commission are Commissioners Larry Ellison and Commissioner Larry Calderon. Joining me as panelists is our General Counsel, Randall Ravitz, our Director of Communications, Cindy Campbell, our Chief Technology Officer, Maurice Myrie, our Deputy General Counsel, Pauline Nguyen, and our Administrative Manager, Jamie Ennis. Maurice Myrie, our CTO, will be providing technical assistance throughout this hearing. Joining us remotely from the MPTC are Chief Robert Perullo, the Executive Director of the MPTC, James O'Brien, the General Counsel and Chief of Staff, Andrea Nardone, the Chief of Training, and Denise Flagg, its Legal Issues Coordinator. Joining us from the Executive Office of Public Safety and Security is the Deputy General Counsel, John Melander. By way of background, the Mass General laws required that the POST Commission and the MPTC to jointly issue regulations on the use of force by law enforcement officers. These two agencies promulgated such regulations as Chapter 6.00 of Title 550 and as Chapter 6.00 of Title 555 of the Code of Massachusetts Regulations. Section 604 of each set of regulations originally stated, except to temporarily gain, regain, or maintain control of an individual and apply restraints, a law enforcement officer shall not intentionally sit, kneel, or stand on an individual's chest, neck, or spine, and shall not force an individual to lie on their stomach. The two agencies have since adopted emergency amendments to strike the word neck and add a sentence stating that, quote, in no event may a law enforcement officer intentionally sit, kneel, or stand on an individual's neck or head, end quote. They are now proposing to make those amendments permanent. At this hearing, we will receive oral comments concerning the proposed amendments from those of you who wish to offer them. Since at least September 20th of this year, we have invited members of the public to request that they be placed on the speaker list for this hearing and to submit written comments on the proposed amendments. If you did not previously ask to be placed on the list, you may do so during the hearing by utilizing the chat function to identify yourself and your wish to provide testimony. If you have called in by telephone, you can signal your interest in speaking by pressing *9 on your phone. After my introductory remarks, we will call on those who have expressed an interest in speaking. We will unmute you when it is your time to offer comments. We ask that when it is your turn to speak, you begin by telling us your name and then proceed to offer your comments. Please limit your comments to approximately 5 minutes so that all who wish to speak can be heard and have an opportunity to do so. After we have called the names of everyone on the list, we will invite comments from anyone else who may wish to speak but did not ask to do so previously. Please be aware that we are here to listen to your oral statements, and we will accept whatever written submissions you may wish to provide. But we will not be answering any questions or discussing any comments you may make at this hearing. If you need any technical assistance, please let Mr. Myrie know, and we will be happy to offer assistance. You can also do so by utilizing the chat function available at the bottom of your screen. We will continue accepting any written comments that you or others may wish to submit until 5 p.m. today. Instructions for submitting written comments may be found on the Post Commission's website. If you're interested in commenting on matters other than the proposed amendments that are the subject of today's hearing, please send us a message with your full name and summary of your comments, either by utilizing the chat function or by sending an email to the address that is listed in the instructions for submitting written comments on the Post Commission's website. With that introduction, I will now open it up for anybody who may wish to provide oral testimony.
Enrique, just one point of clarification. There is not a chat functionality. It's actually off. At deactivated, they would just have to raise their hand, hit the raise the hand button on the lower side. There's no chat function on these meetings. Just
thank you. Thank you for that clarification. So as Maurice said, please indicate your wish to speak by clicking on the raise hand function to identify yourself, and Maurice will make you a panelist, which will allow you to then enter the webinar and provide testimony. Maurice, I see, I believe Senator Collins has raised his hand.
Yes, Senator Collins has. I'm going to allow him to talk right now and bring him into the session. Bring in Senator Collins in.
Hello?
Yes, good morning, Senator. We can hear you.
Good morning. Thank you. Okay, great. Yes, I appreciate the opportunity to testify this morning. I know that you're dealing with a few matters in general these last few weeks, and one in particular I wanted to speak about was around the issue of Section 12 interventions. And though I think the clarification that was made statewide is really important, I think it's also important to distinguish departments that are doing things already in advanced fashion. One of the debates that came up around the creation of the post was, at the outset and sort of governed use of force and other elements was the standards that were kept by the Boston Police in their rules and regulations, along with that of the state. But this issue is a very complicated one. I have personal experience with loved ones who've had to be in these situations, and they're not easy. They're not easy for the professionals on any side. And I think the city of Boston, given their role in the challenges that we're facing as it relates to mental health and substance abuse, whether they're residents of Boston or not, but that are here, and the Boston Police are dealing with a lot of very, very complex issues, which is required them to collaborate as they do very well proactively with the mental health and social service community, like the best clinicians. And they've come up collaboratively with policies and procedures that have been put forth that they've been operating under. And so I think, it's important to communicate statewide, as you have, to departments about their obligations, and I guess I don't know if you call it protections, but sort of authorities under the use of force regulations to do those interventions. But I think they've been getting mixed messages along the way, in addition to collaborating with the mental health and social service community within Boston to come up with this rule and regulation 203A, which I think should be considered by the Post Commission as an acceptable regulation to govern what they're doing in Boston. Clearly more complex, larger volume of cases than than almost all the parts of the state, given our hospital network, etc. But I do believe that examining that to give Boston police the surety that what they're doing is appropriate and is protected and is supported, because that's sort of the path they've been on in collaboration, and don't want to be sort of second guessing what they're doing or being challenged for what they're doing based off of what I think has developed and sort of confused narrative. But I understand what the Post is doing here. I appreciate it. Across the state, they need to know, but I think there's some room for further review of Boston's Rule 203A by the Post Commission, and whether that can be the standard that they can operate under going forward, or they continue operating under going forward, because they are using very sophisticated techniques and very much in the de-escalation fashion. But again, in collaboration, this rule is developed with best clinicians and others who are in the social service and mental health space. So just wanted to put that out there and ask that you consider that.
Thank you, Senator. Thank you for your comments and testimony. And we'll be like all comments and testimony that we receive, we'll make sure that the rest of the commissioners also hear those points of view. But that, of course, includes two commissioners here with us today from Boston, Commissioner Ellison and Commissioner Calderon. Commissioner Calderon, did you want to add something?
Yeah, thanks, Mr. Director. Senator Collins, just want to say on behalf of the members that you represent and I represent, we do appreciate you coming on. This isn't your first time on here, and I want to reassure you that the executive director and the rest of the commission has taken your advice and your points of view past, and truly here today we'll be talking about them again. So I just wanted to say thank you and appreciate you coming on, and let you know that that the entire commission has listened to what you've said in the past. Thank you.
Thank you, Commissioner. Once again, thank you, Senator Collins. I'm going to move on to anyone else who may want to provide oral testimony. I see the list of attendees. We have a couple dozen attendees. Anybody who would like to provide testimony, please indicate your desire to do so by clicking on the raise your hand function at the bottom of the screen, and Maurice will identify you, and Maurice will bring you in as a panelist to be able to provide testimony. Maurice, I think I see Chief Bill Brooks.
Yes, I'm gonna bring in the chief now. Yep, I'm gonna allow him to talk.
There you go.
Hello.
Good morning, Chief Brooks. We can hear you.
Thank you very much, sir. I just want to circle back. This is not on the issue, I think that's before the commission, but it relates to the use of force regulations. I just want to circle back and follow up to my letter from about a year ago regarding the definition of de-escalation, to include that an officer should consider summons as opposed to a custodial arrest. And I appreciate that the commission removed that from the specific requirement. But what's left is that a law enforcement officer shall not use force upon a person unless de-escalation tactics have been attempted and failed or are not feasible. And in the definition of de-escalation, it still does include to consider a hearing or a summons as opposed to an arrest. And, you know, the issue has not come up in the past year that I'm aware of, but I anticipate that it will, that when an officer is faced with a passively resistant subject who won't get out of his car, won't get out of the booth in the restaurant, won't put his hands behind his back, you know, won't unclench his fist. These are all people who are passively resistant, and that we have to use de-escalation, which is fine, but to have included in de-escalation that the officer should consider a summons instead of an arrest. I just don't think we should incentivize people who resist the police by letting the public know that all they have to do is resist, and the officer will need to walk away. I think it's a dangerous precedent. I think it's poor. And again, I appreciate this. That particular phrase was in two places in the regulations, and it was removed from one, but it remains in the definition of de-escalation. And I would urge the commission to remove that. The judgment and discretion of an officer to choose a summons over an arrest happens every day in the Commonwealth in all sorts of minor offenses. But that judgment and that discretion and that decision by the officer is perhaps a training issue, a cultural issue, maybe a policy issue. It does not belong in use of force regulations that require the officer to do that. I just think that that's misplaced. Thank you.
Thank you, Chief Brooks. I'm reminded of that topic, and we'll make sure to bring that concern again, and maybe for discussion at the next commission meeting, which is this coming Thursday, in which we will be taking up voting on the proposed amendments. So again, thank you for your testimony.
I do see another, Larry, Commissioner
I think Commissioner Calderon also wanted to say something, Commissioner.
Thanks again, Mr. Director. I just wanted to reach out to Chief Brooks and say thank you to him as well. These are the unintended consequences that I know as a commission we continue to talk about when we're putting together these regulations with the help of the MPTC. But there are many concerns of not just the rank and file that I represent, but from the Chiefs Association as well. So I just wanted to say thanks to Chief Brooks openly. Thank you, Mr. Director.
Right. Yeah, and to that end, Commissioner and Chief Brooks, we have the tools at the commission of issuing advisories, just like we did on what Senator Collins was referring to, the Section 12 issue. This could be a matter that we can clarify by advisory, not necessarily in regulation. But thank you. Thanks again for your comments. Maurice, I think I see Mr. Thomas Pratt, who
Yep.
has identified himself.
Yeah, I'm going to let him into the room now.
Good morning, Mr. Pratt.
You're actually muted, Mr. Pratt.
If you can unmute yourself, sir. Do I have, let me see. You are on mute, Mr. Pratt. Can you hear us?
I just asked him to unmute.
I did this. I
There he
hear it.
is. You're unmuted now.
Can you hear us, sir, Mr. Pratt? Good morning. Mr. Pratt, can you hear us? We cannot hear you. You seem unmuted, but we cannot hear you.
Hmm. I'm gonna take him out the room and then have him raise his hand again.
He's raised his hand again.
Can you hear us, Mr. Pratt? You're still in the room. I see your hand raised.
You're not on mute. Are you speaking? And
I would suggest that you sign out and sign back into the meeting again. I'm gonna remove you from here right now.
that's unfortunate. Is he still signed in? I see him signed in.
Correct, he's still signed in. I would suggest that he signs out and signs back in just to make sure there's not a technical aspect to this.
Okay. Do you want to let him use the Q&A? The Q&A function is available, right, Maurice?
Correct, yes, he can write the question in the Q&A. Correct.
Mr. Pratt, do you want to say something or write something on the Q&A function? Mr. Pratt, would you like to try what Maurice is suggesting, sign out of this webinar and just go back and try again? Maurice, do you want to bring Mr. Pratt again? Even though
Sure.
he hasn't raised his hand, see if he can hear us.
Yeah, I'm gonna bring him into the room now.
Yep. Mr. Pratt, if you still wish to speak, you're muted. Do you want to try unmuting yourself to provide testimony? We should try it one more time. Or do you want to try the Q&A function at the bottom of your screen to type up anything you may want to communicate with us? All right, well, let's try, Maurice, let's go back and, put him back in the attendee list. And if Mr. Pratt would like to log off and log back into the webinar, this would be we could try hearing from you later on. He seems to have left, right, Maurice? He may be trying.
That is correct.
He may be trying. Okay, in the meantime, I keep seeing the list of attendees. As a reminder, if you are, if you would like to provide a testimony on the proposed amendments to the regulations on the use of force, that please do so by identifying yourself by clicking on the function that says raise hand at the bottom of your screen. This will enable us, Maurice in particular, to bring you in as a panelist to have the ability to provide oral testimony. Is there anybody who would like to speak at this point? I think I see Mr. Pratt again. Mr. Pratt, do you wish to speak? Maurice, do you want to bring him in as a panelist since he identified himself before?
Yes, I'm gonna allow him to talk now.
Oh, I see I see now a question. Somebody wrote, Mr. Pratt wrote on the Q&A function. It says, sorry for the technical difficulties. The last two paragraphs of the joint post MPTC rule concern me. It's duly noted. Is there additional testimony that you want to provide, sir? And Maurice, he went back to the attendee list. Was that your making or?
Correct. I put him back in the attendee list because he put his question. There's another one in there, another statement in there. In the question and answer.
It says he takes the discretion away from the responding officers. Well, what I was most interested as well, these points are duly noted, but I was more interested in making sure that we allowed you to speak if that was what you wanted, sir. If you can corroborate that and just either type it up on the Q&A function if you want to speak, or type up the raise hand function. I understand you may be having some technical difficulties with your platform, but we could not hear you when we tried to bring you in as a speaker. I see a question, well, a point, really a comment from Dennis Goggeben. He says, we have wasted 15 minutes on technical difficulties. That's a point taken. Why can't we have in-person hearings? We try to do our best given what we have. If you would like to provide oral testimony, which is the same as having an in-person meeting, you're welcome to do so. Would you like to provide testimony at this time, sir? All right, Mr. Pratt says he cannot log in for some reason and that he has sent 2 emails on this topic, and I do recall those emails. And as I have stated before, all of the comments that are also submitted in writing are taken into consideration in the promulgation and finalization of these regulations. Is there anyone else who would like to offer oral testimony at this time? I see another comment saying that you didn't answer the question. Give us a location for in-person hearings. Things will be more efficient in person. As I stated in my opening remarks, we are not here to answer questions, even though I effectively just did. We have availed ourselves of the authority we have to issue these, to have these hearings virtually, which do have a lot of attendance from throughout the state. And we believe that they serve the purpose that as intended to hear oral testimony. So Sarah, do you have any comments to make on the proposed amendments to the regulations? I would be happy to entertain them now. All right. Are there any other individuals who would like to offer oral testimony on the proposed amendments to the regulations on use of force? Maurice, I see Mr. Thomas Pratt logged in twice. Do you want to try to move one of his logins to be a panelist, see if he can hear us and provide, or rather, if we can hear him?
Sure, I'm going to bring one of them in right now.
Mr. Pratt, can you, if you can hear us and want to provide oral testimony, feel free to unmute yourself and do so at this time. Maurice, is it possible to bring the second login on Mr. Pratt as a panelist without
Yes,
letting out,
he's in the room twice now.
Mr. Pratt, you're in the room twice. If for some reason you have two different devices and want to try one of them, unmute yourself if you would like to provide oral testimony. Mr. Pratt appears to have sent a couple of points saying that it looks like the technology won't work, and appears to acknowledge that we've tried it. Thank you for your comments, sir. We'll send you back to the list of attendees. And as I have stated before, we have received your emails and acknowledged them and taken them into consideration as we continue with the regulations and any advisories that might follow on the use of force. And I know your concern was similar to Senator Collins, who provided testimony at the beginning as it relates to specifically to Section 12. Are there any other members of the public?
I do see his hand raised again,
Okay,
so I'm going to allow him in.
okay.
Sir, can you hear me?
We can hear you now, sir. Yes.
I'm sorry, and I thank you very much for your patience. I just want to say, I know I've sent some emails to the Post Commission, and sometimes they may seem short or a little angry. Believe me, they're not. They're well thought out, and especially you, Mr. Director, I appreciate the fact that you do read them and you do send me feedback. I know as a police officer, I'm also a union delegate. I'm elected, just expressing the concerns of my constituents. But the rule that has been promulgated, or the rule that you guys are going to be voting on with the MPTC, the Joint Post Commission, the last two paragraphs of that I have great concern with, because it says the regulation in this CMR do not allow officers to substitute their own judgment for those of licensed mental health professionals after determination has been made under M.G.L. 123/12A. I just want to say, I've been in the doorways with officers, and those are ever evolving. Just because a doctor or a psychiatrist or someone in the medical profession signs the 12A doesn't necessarily mean it's right, especially if there's time that has gone by. And a majority, like 29% to 30% of those are filled out incorrectly. If I did that with a search warrant, I would be decertified for being not doing my due diligence. I just think when we put things into writing and where police officers' hands are tied, I just think we're going down a path that we may not want to go. I think that the Boston Police Rule 12A that was rewritten after a pilot program, after input, is a far better foundation to work off of, especially where major publications came out in favor of it, that there were people in the medical community that came out in favor of this. And as far as use of force, in it's in the deadly force, it said you may not use deadly force on a person who is alone or in a room by themselves, or however, but we don't know what we're getting into when we go into a room. I know de-escalation, everybody is taught de-escalation now, but as Larry, as Commissioner Calderon, Allison, and the chief from Pittsfield, when you are standing in the doorway or when you are going to a call, you don't necessarily know what's on the other side of that door. I think by putting hard, fast regulations or hard something in black and white like this, it's just going to turn into a litigious incident. It's going to give attorneys to just an upper hand. Like I know it's just as a guideline, but did you follow the guideline? I tried to follow the guideline. Did you? Yes or no? Well, I tried, but I couldn't. We're in a black and white society now, and it's not the Post, but you know, the majority of things going on in this country now are anti-police, and by putting this into black and white, I think we're giving people like just you know, a reason to come after us. This does not. We don't have guaranteed indemnification. If we're going to put this into black, will the Post a regulation or support a law change indemnifying all police officers trying to, you know, I'm sorry, I got a cold. The section 12 and 35s, where you indemnify those officers trying to affect one because they're not criminal, they're civil. These are civil processes, and we're going in possibly kicking doors in escalating, even though we try to de-escalate. So I think I've jumped around a little bit. I'm sorry, I'm a little rattled by the technical difficulties I was having, and I appreciate you guys bearing with me. But, you know, would the Post support a law change or a law that indemnifies police officers when they are affecting a section 12 or a section 35? That's basically what I have to say. And I honestly appreciate you guys dealing with my technical difficulties today. And thank you. Thank every one of you guys for doing what you do. I appreciate it.
Thank you, sir.
Thank you, sir. I'm glad we were able to finally make it happen. I will note, if you don't mind, you initially referred to the section 12 language, the last two paragraphs, as a regulation, but you later correctly referred to them as guidance. The guidance that we discussed on section 12 recently at the Post Commission was meant to clarify that the proposed use of force regulations, that the promulgated use of force regulations in no way are meant to address the current status of section 12. But we get your comments there and points. They're larger than just that. And as I have mentioned before, we'll ensure that those comments are taken into consideration by the rest of the commissioners and the MPTC. Thank you for your comments. Is there anyone else who would like to provide oral testimony at this time? Once again, this is a public hearing of the Post Commission and the MPTC, a joint public hearing to hear testimony on the proposed amendments to the regulations on use of force, specifically section 604 of the Code of Massachusetts regulations. If you would like to provide oral testimony, and we've been hearing testimony since 9 a.m. this morning, if you would like to provide oral testimony, please indicate your desire to do that by raising your hand, and that is clicking on the raise hand functionality at the bottom of your screen. This will allow us to identify you and bring you in as a panelist for you to provide oral testimony. As mentioned before, we have been, since September 20th, we have been receiving written testimony on the proposed amendments, and will continue to entertain written testimony until 5 p.m. this afternoon. The proposed amendments are scheduled to be considered in final form at the post-commission meeting this coming Thursday. Once again, this is a public hearing, a joint public hearing of the Post Commission and the MPTC on proposed amendments to the use of force regulations. We are here to hear all oral testimony, and we're scheduled to be here until 11 a.m. this morning. If you are in attendance and would like to offer oral testimony, please indicate that desire by clicking on the function Raise Hand or submitting a question in the Q&A function at the bottom of your screen. Once you identify yourself, we'll bring you in to be a panelist, which is what will enable you to provide oral testimony. Is there anybody at this time who would like to do so? Good morning, everyone. It's the top of the hour, and I just want to remind those in attendance that we have been conducting a public hearing on the proposed amendments to the regulations of use of force that are jointly promulgated by the MPTC and the Post Commission. We have heard testimony this morning from some of you. I have seen some participants leave. That participation has decreased slightly, but just in case there are new attendants, I will repeat some of my introductory remarks and ask if there is anyone who would like to provide oral testimony. As mentioned before, today's hearing concerns proposed amendments to the regulations governing the use of force by law enforcement officers, which regulations have been promulgated by the two agencies, the MPTC and the Post Commission. As mentioned before, the hearing is being recorded, and we ask that you mute your audio when it is not your time to speak. The joint regulations in questions are Chapter 600 of Titles 550 and Chapter 600 of Title 555 of the Code of Massachusetts Regulations. Section 604 of each set of regulations originally stated, quote, except to temporarily gain, regain, or maintain control of an individual and apply restraints, a law enforcement officer shall not intentionally sit, kneel, or stand on an individual's chest, neck, or spine, and shall not force an individual to lie on their stomach, end quote. The two agencies have since adopted emergency amendments to strike the word neck and to add a sentence stating, quote, in no event may a law enforcement officer intentionally sit, kneel, or stand on an individual's neck or head. They are now proposing to make those amendments permanent. At this hearing, we have been receiving oral comments concerning the proposed amendments from those of you who wish to offer them. Since at least September 20th of this year, we have invited members of the public to request that they be placed on the speaker list for this hearing and to submit written comments on the proposed amendments. If you did not previously ask to be placed on the list, you may do so during this hearing by utilizing the chat function. If you're calling in by telephone, you can signal your interest in speaking by pressing *9 on your phone. If you need any technical assistance, please let Mr. Maurice Myrie know, and we will be happy to offer assistance. As mentioned before, we will continue accepting any written comments that you or others may wish to submit until 5 p.m. today. Instructions for submitting written comments may be found at Post Commission's website. If you're interested in commenting on matters other than the proposed amendments that are the subject of today's hearing, please send us a message with your full name and a summary of your comments, either by utilizing the chat function or by sending an email to the address that is listed in the instructions for submitting written comments and on the Post Commission's website. At this time, I will once again ask if there are any individuals who would like, in attendance, who would like to offer oral testimony at this time. If you so desire, please indicate your desire by clicking on the raise hand function at the bottom of your screen so that we can identify you and bring you in as a speaker. Are there any individuals who would like to provide oral testimony at this time? Seeing no individuals who would like to offer testimony, I'm going to go ahead and go into a recess. We will be here until 11 o'clock this morning as scheduled. We will reconvene at 10:50, just 10 minutes prior to 11 o'clock. This webinar will remain open and we'll continue to monitor the raise hand function and the Q&A function. But Maurice, if we can just share the screen, that we will resume just before 11 o'clock in case there are any individuals that at that time would like to offer any additional oral testimony. So with that, we'll resume at 10:50 a.m. this morning. Thank you. Good morning, everyone. Good morning again. We are back from the recess we have taken this morning. As stated before, we have been conducting a public hearing on the proposed regulations for the amendment of the use of force regulations, the proposed amendments on the use of force regulations from both the Post Commission and the MPTC. Earlier this morning, we heard testimony from some of the participants. Thank you for all of those contributions. I see that the list of participants has decreased somewhat, but there's still members in attendance. So at this time, I would like to call on anyone who may wish to provide oral testimony on the proposed amendments to the use of force regulations. We're scheduled to be here until 11 o'clock this morning. So if there's anyone who would like to provide oral testimony, please indicate your desire to do so by clicking on the raise hand function at the bottom of your screen, or by indicating your desire to provide testimony by writing a comment on the Q&A function, also at the bottom of your screen. When we recognize you, we can bring you in to be a panelist, which will give you an opportunity to provide oral testimony. As mentioned before, we are accepting written testimony or written comments until 5 p.m. This afternoon. And the matter is to be taken at the commission meeting, at the next commission meeting on Thursday of this week at 8:30. So once again, is there any individual who would like to provide comments on the proposed amendments to the use of force regulations? Please indicate your desire to do that by raising your hand or identifying yourself. Good morning again, and once again, and for the final time this morning, I will mention that we have been conducting a public hearing on proposed amendments to the regulations on use of force. These are regulations that are jointly promulgated by the MPTC and Post Commission. I would say one last time, if there are any individuals who would like to provide oral testimony, please indicate your desire to do so at this time. You can do that by clicking on the raise hand function at the bottom of your screen, or by writing anything on the Q&A function also at the bottom of your screen. Seeing that there's no more individuals wanting to provide oral testimony, let me mention once again, or finally, that on behalf of the Post Commission and the MPTC, I would like to thank each of you for participating in the regulation process. The public comment period is integral to the establishment of effective regulations. Following the conclusion of this hearing and the period for submitting written comments, we will carefully consider the oral and written comments that have been offered. We anticipate that the proposed amendments will be discussed at duly noticed public meetings of the Post Commission and the MPTC. If the two agencies decide to make the amendments permanent, they will be published in the Massachusetts Register, at which point they will become effective as permanent regulations. So once again, we will be taking written comments up until 5 p.m. this afternoon. And from the Post Commission side, we expect and noticed that we will be discussing these amendments in final form at the Thursday meeting this week. This meeting has been already posted and will take place at 8:30 on this Thursday. With that, let me once again thank every one of you for participating and attending, for all the staff that attended and is taking great notes. And I will now adjourn this hearing and close it. Thanks, everyone.